Local jurisdiction of the court and the police. Local jurisdiction of the court and the police. Some basic consideration. As seen early, every state is divided into suitable territorial unit for the purpose of the administration of the criminal justice. Purpose of the administration of the criminal justice. Also, for these territorial unit, separate court have been established. For these territorial units, separate court has been established. Full stop. Now, having regard to the size of the state, the distance of the court from the place of the crime and difficulty of the transport in the interior, it would seem expedient and desirable that the inquiry or trial in respect of the any offense should ordinarily take place in that court which is nearest to the place of crime. Nearest to the place of crime. Full stop. If the trial is conducted in the immediate vicinity of the crime, witness will be readily available, and it could be convenient for both the prosecution and the defense. Moreover, trial in such a nearby court is more conducive to the sense of the social security. Therefore, the purpose of the determining the venue or the place of the trial. Venue or the place of the trial. The basic general rule is every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Whose local jurisdiction was committed. Section 177. The word ordinarily in the above section 177 suggests that the section is a general one and is subject to other special provision of the code or any other law. The subsequent Section 178 and 184 provide for alternative venue for inquiry and trial under certain circumstances. In respect of the certain kind of offense. Full stop. This arrangement is intended essentially to minimize the inconvenience that might be caused by restrict. 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 Okay, that might be all these all these all these rule regarding the venue of trial have been made applicable by section 156 clause 1 in respect of the intimation of the proper police station with could entertain investigation in connection with any offense. हो गया. Special provision providing for alternative venue in each of the following case. The offense may be inquired into and tried by any court having jurisdiction over any of the local area mentioned therein. In offense is committed, but it is uncertain in which of the following cervical local area it was committed. Section 178 clause 1. In offense was committed partly in one local area and partly in another. Section 178 clause B. In offense is continue one and the same is continue to be committed in more and than one local area. 178 clause C. 178 clause C. 178 clause C. Okay, 178 179 179 181 क्या कहता है. In any offense of being a thug or murder committed by in a thug or of dacoity or dacoity within murder of the belonging to a gang of the dacoity or of escaping from custody was committed in one local area and the person accused of such an offense was found in another local area. 181 clause 1. 181 clause 181 क्लोज 1 हो गया। इन ऑफेंस विच including the possession of the stolen property was committed in one local area. Committed in one local area, okay, committed in one local area. Special rule in case of jointer of the charge and jointer of the offender. Jointer of the offender हो गया, jointer of the offender, jointer of the power of the state to order case to be tried in differentiate session division. Differentiate session division, notwithstanding the above rule regarding the place of inquiry or trial, the state government may direct that any case or class of case committed for trial in any district may be tried in any session division. Any session division whoever such direction of the state government is not be in repugnant to any direction provision issued by the High Court or the Supreme Court under the Constitution or any other law. Section 185. 185. Section 185. Full stop. The power conferred of the state government by the above section 185 is in extraordinary power intended to be used only when some consideration of the public interest. The power conferred on the state government by the above section 185 is in extraordinary power tend to be used only when some consideration of the public interest, maintenance of the public order during the trial of a sensational case, justifying the holding of a session trial in a different session division. It may be noted that throughout Section 185 restrain the state government from passing any such order which is repugnant to any direction issue early by the High Court or the Supreme Court. In this behalf, the High Court on the Supreme Court, whoever free to give any direction overriding the effect of the order passed by the state government under the Section 185. High Court power to decide in case of doubt the place of inquiry or trial. Place of inquiry or trial हो गया. Magistrate power to inquire into in offence committed outside this local jurisdiction. Outside this local jurisdiction. Power to inquire into of over trying offence committed outside India. When the offence is committed outside India by a citizen of India, whether on the high sea or elsewhere, or by a person not being such citizen on any ship or RT aircraft registered in India. Aircraft registered in India हो गया. Aircraft registered in India हो गया. Aircraft registered in India हो गया. Aircraft consequence of failure to follow the rule regarding local jurisdiction. The jurisdiction of a criminal court is of the two kind. Jurisdiction of a criminal court is of the two kinds. Full stop. One has reference to the power of the court to try particular kind of offence. Full stop. This jurisdiction goes to the root of the matter, and if a court which is not empowered to try a particular offence does try that offence, the tried trial shall be void. Full stop. The other type of the jurisdiction of the court is the territorial or local jurisdiction, which determining according to the rule discussed above and condition in section 177 and 188. Full stop. If these rules are not compiled with, the trial or other proceedings shall not be set aside, has been void unless void unless Lecture number 7. Cognizance of offence. Cognizance of offence and commencement of judicial proceeding. Judicial proceeding after the stage of the investigation is complete and the final report is forwarded Final report is forwarded by the police to any competent magistrate. The second important stage of the giving fair trial to the accused person being accused person being has a prosecutor of this second stage the code in which some primarily step हो गया in primarily step full stop they are to cognizance of the offense to take cognizance of offense to ascertain whether any prima facie case exists against the accused person, and in case it does so exist then to issue process against the accused person in order to secure this presence at the time of this trial be supplied to the accused person to copy of the police statement to consolidate proceeding pertain to the same case per, per time to the same case for if the case is exclusive trialable by a session court to commit the case to that court. Okay, these matter will be discussed in the present lecture. Cognizance of offense meaning taking cognizance of an offense is the first and the foremost step toward trial. Full stop. Cognization literal meaning knowledge or notice, and taking cognizance of offense mean taking notice or becoming aware of the legal commission of an offense. Full stop. Obviously the judicial officer will have to take cognizance of offense before he could proceed to conduct a trial. Full stop. The code has no define or specially explain the expression cognizance of an offense or taking cognizance of an offense. However, the meaning of the express is now well settled by the court. Full stop. Taking cognizance does not involve any formal action or indeed action of any kind, but occur as soon as magistrate has such apply this mind to the suspected commission of offense for the purpose of the proceeding to take subsistence step under section 200, section 202, section 204 toward inquiry and trial. It included intention of the initiate a judicial proceeding against in offender in respect of the offense or taking step to see whether there is a basis for initiated judicial proceeding. Full stop. The magistrate order taking cognizance should reflect the application of this mind, and in the context of the receiving a complaint under section 200 CRPC, and the Supreme Court said that is neither practicable nor desirable to define as to what is meant by taking cognizance. Full stop. The question has to be whether the magistrate has taken cognizance of offense or not would depend upon the fact and circumstance of the given case. Full stop. It is tried that before taking cognizance the court should satisfy that the ingredient of the offense charge are there by following class of magistrate and court can be take cognizance of offense. Any magistrate of the first class may take cognizance of any offense. Section 190 clause 1. Any magistrate of the second class, if specially no improved empowered, no empowered हो गया, no empowered.